Good evening, everyone. Thanks for coming on this, I guess, not so cold Chicago night. I'm coming from Southern California, so it's pretty cold out there. My name is Yaron Brook. I'm the Executive Director of the Ayn Rand Institute. Welcome to our third talk of the Ayn Rand Center for Individual Rights speaker series in Chicago. The Ayn Rand Center for Individual Rights in Washington, D.C. is our public outreach and policy division of the Ayn Rand Institute and is responsible for events like these. The center, named after the author Ayn Rand, whose novels Atlas Shrugged and The Fountainhead demonstrate why individual rights to life, liberty, property, and the pursuit of happiness provide the only moral basis for a truly free, laissez-faire capitalist society. And that's what these talks have been and will be dedicated towards. In addition to public talks, ARC engages with those in public policy organizations and with public intellectuals in debates and panel discussions about current issues and the foundations of politics. We write, speak, the television appearances that you might see, the editorials and newspaper stuff, that's all coming out of our ARC program. We have a bunch of different websites. I encourage you to go to a website dedicated to the principles of a free society. It's designed to have content of the principles that are going to be required for forming such a free society. It's principlesofaFreeSociety.com. I'd like to thank our donors and sponsors tonight for tonight's talk. We have our sponsors. We have Tim Bloom, David Strasberg, Jonathan Honing, Don and Linda Duhl, Russ Rosenzweig, and William Greichner, and one anonymous sponsor. So thank you all for making these events possible. In addition, there's several donors who've given smaller contributions towards these talks. Thank you all for doing so. We hope to be extending these talks. The next talk I expect will be in early February here at the Hyatt, and I will probably be the speaker, and it'll probably be something on the moral defense of the financial industry. So please let all your financial industry friends here in Chicago know about it. I'd also like to thank our volunteers who are members of the local Chicago Objectivist Society who help make these events possible, help us keep the cost of these events reasonable. You know, we live in interesting times, I guess the Chinese say, depressing times, difficult times. Difficult times, I think, for all of us. Difficult time for anybody in the financial industry right now, particularly if you run a hedge fund. Difficult times for this country. And while we just had an election that seems to have moved things a little bit in a saner direction, it's a little bit from a very bad place. It's just a little bit, and who knows what these Republicans will ultimately do. It's certainly better than alternative, but it isn't much of a solution. Philosophically, you know, in terms of fundamental ideas, this country, this culture is clearly going dramatically in the wrong direction. Again, we might have these small corrections, but the general trend seems overwhelmingly negative. These are really difficult times. And I think there's never been a more important time for the kind of work we do at the Institute and bringing Ayn Rand's ideas to the next generation of voters, the next generation of intellectuals, the next generation of business people. There's never been a more important time to do that. You know, I as the executive director of the Ayn Rand Institute, really take seriously the notion that the fate of Western civilization, the fate of this country, is dependent on our ability to be successful at doing just that. We have to fight an intellectual, philosophical, ideological battle out there against overwhelming odds, against a very well-established establishment, intellectually, monetarily, you know, philosophically. So I appreciate all the support I get and we get from you guys. I very much appreciate you being here. And in that battle for changing this culture, we're going to have to deal with a lot of different issues because the bad guys have entrenched themselves, established themselves they have answers, or they think they have answers to almost every question out there. And I certainly think that intellectual property right, as we'll see, really the core of what property rights are all about, is one of those areas where the battle is going to be waged. If you lose intellectual property right, you lose it all. You really lose it all. So thanks for coming tonight. It's a real pleasure for me to introduce our speaker tonight on the subject of why business leaders should care about intellectual property, Ayn Rand's radical argument. And it is a radical argument. It's very different than the arguments you will hear from non-objectivists. Adam Mossoff is a professor of law at George Mason University School of Law and has published widely on topics of intellectual property and property law. His research focuses on the intersection between intellectual property law and property theory, with a special emphasis on natural rights philosophy and its role in intellectual history of patent law. He graduated with honors from the University of Chicago Law School, where he was a research assistant to Richard Epstein. Professor Mossoff was a John Olin Fellow in Law and a visiting lecturer at Northwestern University School of Law, and clerked for the Honorable Jacques L. Wiener? Okay. Junior of the U.S. Court of Appeals of the Fifth Circuit. Adam will speak for about 45 minutes, and then we will have a Q&A period that will last until about 8 o'clock. And I will actually join Dr. Mossoff for the Q&A period, so you can, I know nothing about intellectual property rights, so please don't ask me any of those. But if you want to broaden the questions in the Q&A, I'd be happy to answer any questions you have. And with that, Dr. Mossoff.
Thank you. It's great to be back in Chicago again. I thought I remembered how cold that wind is. But the reality of the wind is very different from the actuality. The reality of it is very different from the memory of the wind. I like to move around a little bit, and I forgot to put this on. And that's okay, Your Honor. Everyone has trouble with my judge's name. He's one of the few, Jacques L. Wiener, Jr. He's one of the few native Louisianians who's Jewish, so he has that wonderful joint heritage. All right. Past several decades, intellectual property rights have risen to prominence in our lives. Right? The modern biotech, the telecommunications, the high-tech computer industries, they're all exemplars of this fact. Right? These companies now produce products that make possible achievements only 50 years ago were thought to be pure science fiction. Heck, I mean, 15 years ago, right? If you had said to someone on a single device, you'd be able to check your email, surf the web, call people, schedule telephone calls, play games, people would look at you like you're crazy, right? And yet we do this now without giving it a second thought. Now more than ever, people are aware that the products these companies sell, the life-saving drugs, the internet services, the notebook computers, the iPhones, the droids, the iPads, etc., these aren't just physical goods. These are intellectual property. Now, intellectual property is a general category. It stands for a set of different types of rights. There's patents, which are property rights in inventions. There's copyrights, which are property rights in writings and songs. There's trade secrets, which are property rights in business models. And then there's trademarks, which are property rights in logos. These all fall within the general category of intellectual property. I'm just going to refer to as IP for the rest of the talk, just for shorthand. It's a little difficult to keep saying intellectual property, so from here on out, just say IP. Now, everyone's aware that IP is extremely important, right? It's the source of life, success, happiness, and commercial profit. This is especially true for the business leaders who are using these new intellectual property to form the engine of free enterprise today. A great example is Mark Zuckerberg, the creator of Facebook, in an interview just 2 weeks ago on November 16th, had to explain to his somewhat ignorant interviewer from how the high-tech industry is not zero-sum. He stated, quote, "We're building value, not just taking it away from someone else," end quote. IP is also under widespread attack today. Intellectuals on the left, joined by libertarians, are engaging in a concerted effort to destroy these vital property rights. Leftists, who call themselves the copy left and other types of terms, claim that IP violates our common culture, the public domain, public health. One law professor at Duke says that IP, quote, "encloses the commons of the mind," end quote. He means that critically. Libertarians join in common cause with these leftists. For their part, they argue that IP is a coercive government monopoly that violates the rights to liberty and property. In fact, the libertarians' argument against IP is especially destructive of these property rights, because unlike the statists and collectivists who seek to destroy all property rights, property rights in factories as well as inventions, libertarians are attacking IP rights in the name of a so-called defense of property rights. Unsurprisingly, the labors of these intellectuals has been producing real-world results. Culturally, many people today, especially teenagers and college students, if you teach or have kids, you are very well aware of this, they don't even recognize IP as property anymore. One common result of this is that there's widespread piracy of movies and songs on the internet. Politically, IP rights are on the defensive by so-called public interest organizations and other policy activists who are successfully lobbying for more laws and regulations. Another example is the FCC is about to impose massive price controls and other regulations on the modern telecom companies whose innovative investments and creations have made possible the internet that we now know it today. This goes under the rubric of net neutrality, for some of you who may know it. And also announced today, the European Union is announcing that it's going to begin its antitrust investigations of Google. Legally, IP rights are on the defensive in the courts. In a slew of court decisions over the past 4 or 5 years, the Supreme Court has substantially weakened patent rights. They have made it much harder to obtain patents for inventions, and they made it even harder for existing patent owners to both license and profit from their inventions in the marketplace. These attacks on IP represent a perfect storm. Contrary to the news stories and the recent election results, the left and the right are united. They are united in a combined theoretical, political, and legal assault on IP rights. Thus, it is absolutely necessary. In fact, I'd say it's vitally important, especially for the firms and creators, the creators of IP and the firms who use IP in the marketplace. It's necessary to identify the moral justification for IP. What is it? Why is it property? And thus, why should it be secured under the law? In fact, almost 50 years ago, Ayn Rand herself recognized the importance of IP rights. In a brief essay that she wrote called Patents and Copyrights, which has been republished in her book, The Capitalism, the Unknown Ideal, she defended these vitally important forms of property against attacks on them at that time. And she saw those attacks for what they were: an assault on man's mind and on the values he produces, and thus an assault on man's life. Now, Rand was able to grasp the basic moral justification for IP because she was the first philosopher to recognize the connection between man's mind and his life. She induced the principle that man's mind, his rational faculty, is his basic tool of survival. In fact, this is the theme of her epic novel, Atlas Shrugged. Now, because Rand recognizes the connection between man's mind and his life, she is the first philosopher to recognize that IP is not merely some type of derivative property right that we understand only by first establishing property rights in land, nor is it merely a property right by analogy, that it simply shares some legal characteristics with property rights in land or other types of property. She recognized that IP is a property right par excellence. Rand's novel philosophical insight here is that all property, whether property in land, a car, a computer, a new drug, or a book, is fundamentally intellectual property. Now, this is important, so it bears repeating. Rand's novel philosophical insight is that all property is fundamentally intellectual property. As such, she explicitly recognizes that IP rights are property rights because they, quote, represent the legal implementation of the base of all property rights, a man's right to the product of his mind, end quote. Now, in proving that property is fundamentally intellectual property, my talk will focus primarily on inventions and the law of patents. First, because this is the area that I typically work in, that I write in, but also because inventions secured as property rights exemplify the values that are produced by the rational man who practices the virtue of productivity. In fact, this is why Rand maintains in that essay that she wrote on patents and copyrights that, quote, patents are the heart and core of property rights, unquote, and that once patents are destroyed, all property follows by necessity. But it's very important to recognize that the claims here apply to all forms of property in IP, not just patents. Also, I'm a law professor, but this is not a law school lecture. So I'm not going to be talking about specific legal rules or doctrines that govern intellectual property. I'm not going to be talking about term limits on patents or the differences between the legal protection between copyright and patents and software and other types of legal issues. If you're interested in that, please ask in the Q&A. But that's not the point of my lecture tonight. My talk tonight is about the moral justification for IP as such. Because this is what is missing from our public discourse about IP. And thus, this is what is so badly needed to be injected into the public discourse. All right, so the structure of my lecture is going to be as follows. First, I'm going to talk about how property rights are rooted in human nature, showing how property is rooted in the production of values that are first conceived in man's rational mind. Second, I'll explain how the values that are secured in IP exemplify this fundamental truth about all property rights. Now here, I'm going to explain how the early patent laws in America exemplified this insight and how courts recognized at that time that patents secured the value produced by the human mind. And then last, with this proper understanding of IP as rooted in man's nature as a rational animal, we can then effectively respond to the critique of IP rights today. Specifically, I'm going to discuss the concept of scarcity that is used by utilitarians and economists to critique IP. I'll show how this attack on IP misrepresents the nature and function of property as such. So ultimately, when one returns to the facts from which we can induce the moral justification for IP, it becomes clear that these property rights rest on two basic philosophic pillars. First, the concept of value, and second, the nature of man as a rational animal whose mind is his basic means of survival. It is on this basis that Rand drew the radical conclusion that all property is fundamentally intellectual property, because property rights secure the values born of man's mind. All right, so let's begin. Now, it's very common today to hear businessmen talk about how their activities add, create, and produce value. Right? This is especially common in the high-tech world. In that interview with Zuckerberg, right, he said, quote, "We're building value," end quote. Right? Now, there's a basic truth to this common refrain. The key to productive activities is that it is rooted in the concept of value. Now, this is one of Ayn Rand's key philosophic insights, one of her important contributions to philosophy as such. And that is at the root of all moral concepts, concepts such as property, is the fact that all living things must pursue and obtain certain things in order to live. Now, Rand calls the object of this life-sustaining pursuit of value, which she defines as, quote, "that which one acts to gain and or keep," end quote. And her succinct formulation, quote, "it is only the concept of life that makes the concept of value possible," end quote. Or in sum, if one wants to live, one must then act to obtain the things necessary to maintain one's life. These goals that one acts to obtain are values. Now, as a rational animal, the values that man pursues are different from other animals or organisms. Unlike hyenas or amoebas, for instance, man must conceive of the values necessary to maintain his life. And it is only after he has first made this conceptual identification can he then act to obtain or create those values. As Ayn Rand observes, quote, Man could not survive even as a herbivorous creature by picking fruit and berries at random. He has no instinct to tell him which plants are beneficial to him and which are deadly. He can learn it only by conscious experimentation or by the observation of other living creatures who do not touch poisonous plants, a procedure which in either case is a process of thought, end quote. Moreover, in addition to this conceptual origin of his recognition of values, there's another important difference between man and other animals. Man must produce or create the material values that are necessary for a successful, happy life. The lion finds the gazelle on the Serengeti, ready for him to kill and eat, right? The rabbit finds the berries in the woods, ready for him to eat, to maintain his life. We do not go out into the woods and find suits and townhomes and cars and nice prime rib dinners, right? We do not find in nature ready-made the materials required for our survival, the clothing, the food, the shelter that makes it possible for us to live. The values that sustain man's life must be produced. And thus, man must not only conceptually identify the values that he has to seek, he must then create these values through additional physical processes, identifying conceptually the skills necessary to cultivate land, to grow crops, to husband animals for food and labor, and to build homes. From this important union of mind and body, land becomes a farm, animals become livestock, and trees and rocks become the timber and cement that make possible our buildings and our skyscrapers. Now today, many people recognize this connection between man's mind and value creation in the context of geniuses or business entrepreneurs who come up with new products or invent new scientific theories. In fact, we all live and flourish today from the inventions and the business innovations produced by the labors of countless great individuals who first conceived and created new values. And the names roll off our tongues, right? Thomas Edison, among hundreds of inventions, the inventor of the incandescent light bulb, the lights that are shining in my face at the moment. The Alexander Graham Bell, right? The inventor of the telephone. And in our new digital era, Jack Kilby and Robert Noyce. You may not know them, but they each independently invented the integrated circuit in 1959, which is the fountainhead of our entire digital revolution of the past 60 years. Unsurprisingly, these men weren't just inventors. They were also owners of patents in their inventions. They are proof of President Abraham Lincoln's famous statement that the, quote, the patent system added the fuel of interest to the fire of genius in the discovery and production of new and useful things, end quote. By the way, President Lincoln knew exactly what he was talking about because to this day, he's the only American president to have obtained a patent on an invention that he came up with, which was actually enforced at the time that he stated this. So he knew exactly what he was talking about. He was one of the geniuses he was referring to. In fact, Lincoln was correct, right? Because it's appropriate to refer to men like Edison and Bell as geniuses. But it's a mistake for people to conclude that the intellectual source of values in human life is limited only to great men with great minds. It is a fact of human nature. It is true for all people. It is true for all people, working at all times and in all endeavors. It's implicit, for instance, in Adam Smith's famous example in his book, The Wealth of Nations, of how the division of labor makes possible a simple, uncomplicated, inexpensive pin, right? The division of labor. Someone had to come up with that idea and figure out how to implement that in manufacturing and business. But the pin is also a great example about the fundamental role of man's mind in his life. You don't need some new biotech innovation, some new life-saving drug, or some new great computer device from Apple like an iPad to prove the point that man's mind underlies all value creation, right? For without pins and needles, there would be no clothing, a basic commodity used since the birth of Homo sapiens. But it's important to recognize that Homo sapiens are a relatively young species on this planet. And man's ancestors existed long without clothing, although they certainly needed this simple protective device as much as man does today. So why then did they not create clothing? Well, the answer is simple. Because for man, for humans, the need for clothing does not create clothing. Man first had to conceive of what are clothes. What are these things that we hang on our body, right? And then figure out how to make them, right? Such as growing them from plants like cotton, or taking them from animals, turning their hides into leather. But that's not enough, right? He had to learn then the skills of actually how to farm and process cotton and how to cure animal hides. But even that's not enough. He then had to learn how to sew. And ultimately in the Industrial Revolution, he learned how to mechanize sewing, combining this important human skill with an equally important technical knowledge in the burgeoning field of mechanical engineering. Moreover, to support the human population that lives today, he must also acquire the knowledge about how to mass produce clothing at low cost, and then how to distribute this product through complex market mechanisms, such as using international supply chains of wholesalers and retailers. Again, exploiting that concept of division of labor that Adam Smith talked about in The Wealth of Nations. Many people today do not realize the extensive conceptual processes required to fulfill the basic survival need in clothing the naked human body. All goods used by man, pins, clothing, light bulbs, computers, reflect the basic truth that man's mind is the fundamental source of the values that sustain his life. Aristotle first recognized 2,000 years ago that man is a rational animal. This was an incredible achievement, incredible discovery of the essential nature of humanity. On the basis of Aristotle's tremendous insight, Rand herself identified an important corollary. Quote, "The action required to sustain human life is primarily intellectual. Everything man needs has to be discovered by his mind and produced by his effort. Production is the application of reason to the problem of survival," end quote. Or, as she ultimately concludes, quote, "Man's mind is his basic means of survival," end quote. This is why the production of values is a moral virtue, because according to Rand, quote, "productive work is the process by which man's consciousness controls his existence," end quote, which means sustains his life. And it is Rand's emphasis on this fundamental unity of mind and body in man's creation of values that led her to the conclusion that all property is fundamentally intellectual property. From the invention of the first fire-making tools up to the complex chemical formulas that are designed today by scientists in the high-tech laboratories of modern pharmaceutical companies, creative thought and action is at the root of productivity. Now, unsurprisingly, the birth of the law of patents in the 18th and 19th centuries was based on the recognition that mental labor is of paramount importance in the values produced by man. In fact, the emergence of the law of patents directly correlates with the birth of the Industrial Revolution in the same time frame, in the 18th and 19th centuries. Now, in my academic work over the past 8 years, I've been investigating this history. And I think it's extremely important and interesting, if only because I've been investigating it. But actually, this is not a lecture about history, and it's very interesting and important, but it's not the focus of what we're talking about tonight. Rather, tonight we're interested in the philosophic truth that man's mind is at the root of the production of values that sustain a flourishing human life. And so we're only going to be looking at the history as evidence for inducing this truth. All right, so as many people know, the Industrial Revolution fundamentally altered human life in the 19th century. In fact, Rand herself noted that the evidence provided by the Industrial Revolution was central for her in inducing her discovery about the role of man's mind in his life. Now, we all know the Industrial Revolution changed our lives, but in what way? Most of us can't think of immediately the concretes that come to mind when we think about what it meant that human life was revolutionized. Well, what was this evidence? Well, just to give you a few examples, within 100 years, within just time frame of approximately 100 years, the following inventions were brought into existence: the steam engine, the steamboat, the cotton gin, the mechanized reaper, machine tooling, including standardized interchangeable parts used in the production of other machines and other objects, the telegraph, vulcanized rubber, the sewing machine, barbed wire, steel, electric generators called dynamos at the time, electric light bulbs, telephones, the combustion engine, gasoline, the fuel combustion engine, etc., etc. This explosion in new inventions went hand in hand with the protection of these new values under the equally new patent, trade secret, and trademark laws. Now, why did American congressmen and courts secure IP rights as property rights under the law? Why did they look to these inventions and say, we are going to protect all of these inventions with patents, which they were? Because they recognized that these were valuable products of men's mental labor and thus morally deserving of legal protection. Now, a full identification of all of the sources that prove this point could take up my entire lecture. Right? I could make this a lecture about the history, but it's not. So I'm just going to have to give you a few representative examples tonight. And for those of you who are interested in the history, because there's a lot of misinformation about the history out there, you can find many others in my various law journal articles, which are available for download on the internet. If you just search my name, you can find them on a website known as ssrn.com. But here are just a few representative examples. In 1824, Daniel Webster, known as the great orator at the time, proclaimed in a speech in the House of Representatives when he introduced legislation to protect foreign inventors under the United States patent laws, quote, "The right of the inventor is a high property. It is the fruit of his mind. It belongs to him more than any other property, and he ought to be protected in the enjoyment of it," end quote. And in 1878, a judge quoted from a legal treatise that the Founding Fathers provided in the Constitution the power for Congress to enact the patent and copyright laws because they wanted to secure to authors and inventors, quote, "a natural right to the fruits of mental labor," end quote. Now, as this judge recognized, the United States of America was expressly created on the principle of the natural rights to life, liberty, and property. In fact, the Founding Fathers were inspired to act to create a new country by the philosophy of natural rights, as probably best articulated by John Locke in his famous treatise, the Second Treatise of Civil Government, published in 1690. Now, Locke, among many other philosophers and scholars, taught the founders that governments are formed to secure man's natural rights, especially the natural right to property. And by the way, Locke also recognized IP as property. Thus, American congressmen and judges followed the logic of this commitment to property rights and secured patent inventions, trade secrets, and other IP rights. They recognized that these were the products of man's mind. In the terms of natural rights philosophy in that day, these were the valuable fruits of an inventor's mental labors. Now, as such, the United States of America soon displaced England as the primary source of the Industrial Revolution. Now, it's hard to realize how shocking this was at the time, right? The United States of America gained its independence from England officially in 1783 with the treaties that concluded the Revolutionary War, and we were broke, heavily in debt, with no local industries to speak of. England was predicting that we would soon return to the mother country, back to the Commonwealth in a couple decades at most. And moreover, not only was this an incredible achievement given that just the origins of the United States, but England was the official birthplace of the Industrial Revolution in the 18th century. It was in England that James Watt and Matthew Boulton patented their steam engine in the 18th century. But England still viewed patents in the same way as other old world European countries. They thought of patents as special, limited, special legal privileges granted to inventors as merely a liege of the crown. It was just a special privilege granted out. In the newly independent and upstart United States of America, things were different. Since the enactment of the first patent laws in 1790 under the new Constitution of 1789, patents were secured as fundamental property rights here. And by the mid-19th century, so a scant 60 years later, England and the other countries were explicitly marveling at the explosion in industrial commercial growth in the United States, where the birth of capitalism produced a cornucopia of goods and wealth never before seen in human history. Now, this was a birth that was precipitated by the strong protection of IP rights here. But unfortunately, American congressmen and judges lacked a definitive justification for why IP was property. See, the early patent and copyright laws were based only on an implicit recognition of the principle first identified by Rand, right? That she explicitly identified that man's mind is his basic means of survival, and that man must conceive of and then produce all values necessary to sustain his life. As I said, these were her radical contributions to philosophy. John Locke, despite his impressive accomplishments, did not make these identifications. Now, this is not a talk about Locke, and so if you're interested in the details specifically of what Locke had to say, I'd be happy to answer in the Q&A. But he rested his argument merely in an appeal to labor. Thus, in the 19th century, with explosion of new inventions, technologies, and other incredible achievements of the Industrial Revolution, there was no objective validation of why these products of the human mind should be secured as property rights to their creators. American lawyers, politicians, and judges could not justify the underlying moral principle at stake, that IP rights secure the values conceived and created by the rational mind, and which are the fundamental source of all values, and that make possible a flourishing human life. So they just had an assertion to make that this was labor. Example, in 1843, in a patent case, a federal judge wrote that, quote, "A man should be secured in the fruits of his ingenuity and labor," end quote. Why? Because, quote, "it seems difficult to draw a distinction between the fruits of mental and physical labor," end quote. Labor is basically the idea, whether mental or physical. If physical labor produces a farm, we protect a farm as property. Mental labor produces an invention, we protect the invention as property. But the fact that the products of mental and physical labor are both deserving of protection of property is not self-evident, and it requires a justification. Now, Rand could herself easily explain why one cannot draw a fundamental distinction between a rightful claim to a farm and a rightful claim to an invention. In fact, she could point out that the seemingly simple physical transformation of fallow land into a value, a farm, is a direct result of the fact that man is a rational animal whose mind is his basic means of survival. In the case of a farm, it's an individual's identification that a particular parcel of land has ideal soil, right? It's not sand, it's not rock, it's a type of soil that's rich with nutrients to which he can apply his agricultural knowledge for the purpose of growing food. And it is only this conceptual identification and the resulting goal-directed action that the farmer takes that the parcel of land then becomes a value. Because it is only at this point that the farmer is acting to gain and or keep the land in a certain way to maintain his life, to produce food. Before this conceptually directed action, it was only land. Just land, a simple descriptive fact of the world. After the conceptual identification and appropriate physical action by the individual, this descriptive fact is converted into a moral value. The land becomes a farm, a source of life-sustaining food for the farmer and for the men with whom he would trade the fruits of his labors. In sum, the same union of conceptual and physical labor that produces a farm also produced the mechanized reaper, the cotton gin, and other patent inventions of the 19th century that were ultimately used in farming that ended up producing massive amounts of food to feed the millions of new human beings that were surviving in that time on the basis of these types of inventions and value creations. It is the fact that both a farm and an invention arise from the valuing rational mind, that both are the rightful property of the man who creates them in order to live. This is why, for those of you who've read Atlas Shrugged, Rand uses this beautiful metaphor. She refers to machines as, quote, the frozen form of a living intelligence. Or another place she refers to a machine as, quote, the frozen form of a mind's ingenuity. Right? It's a great metaphor that captures exactly what makes a machine a machine. It's the mind that has created that thing. Think of that metaphor as opposed to just the metaphor of labor, mixing labor, which is Locke's metaphor for creating property. So much more powerful. Now, since the patent laws and other IP laws lacked an objective validation as being morally legitimate property rights in the 19th century, it's therefore easy to see how we reach the point today that IP is so widely attacked, right? Inventors and the firms that exploit their creations in the marketplace today are called evil monopolists, right, who steal from the public domain or are enclosing the commons of the mind, as I said in the introduction, right? And it's important to remember that it's not just collectivists who are attacking IP rights. It's also libertarians who are attacking IP rights in the very name of the rights to liberty and property. Now here, another one of Ayn Rand's insights is very helpful. She observed that philosophers are the ultimate source of the ideas that all people put into action in their lives. Now, probably the best example of this insight is John Locke and the natural rights philosophers of the 17th and 18th centuries, who came up with the ideas as intellectuals that then motivated the founding fathers to act on them to create this country, to write the Declaration of Independence, to draft the Constitution of 1789, to ultimately write the Bill of Rights. In fact, the United States of America is the very first country in human history, in all of human history, that was explicitly founded on a moral principle, the principle of individual rights, as taught to them by John Locke and the natural rights philosophers. Now, the attack on IP is another example of this insight of Ayn Rand's, that philosophical ideas are the engine behind people's actions or writings. Now, since IP rights lacked a definitive moral justification in the 19th century, they quickly succumbed to a growing cadre of philosophers, legal scholars, and lawyers who agreed with Jeremy Bentham's critique of natural rights as, quote, nonsense on stilts, end quote. Now, Bentham's critique of natural rights philosophy lies at the root of the libertarian and economist's attack on IP today. So it's necessary to understand what Bentham had to say about property to see how his ideas are now being used to attack what Rand refers to as, quote, the base of all property rights, a man's right to the product of his mind. All right, so what about Bentham? Well, Bentham rejected Locke's individualism and the resulting argument of Locke that each man had the right to his life, liberty, and property. Bentham asserted a new moral ideal, an explicitly collectivist moral ideal, the greatest good for the greatest number. In fact, he referred to this as his new religion in a letter, in which he then called utilitarianism. Now, according to Bentham's philosophy of utilitarianism, property does not arise from an individual's value-creating labor. That's the argument of Locke, and that's nonsense on stilts, according to Bentham. Rather, according to Bentham, property is merely an artificial creation of the state. In fact, he famously declared that property and law are born together and die together. So why, according to Bentham, would a government create legal property rights? Well, he had an answer for that. He says, because this provides security and safety to people in their goods. And this security and safety incentivizes them to create more. In other words, property rights are merely laws enacted by the government to increase security, reduce conflict, and thereby maximize the greatest good for the greatest number. Now, Bentham and the disciples of his philosophy of utilitarianism quickly on this basis developed a theoretical attack on IP. Now recall, remember the American judges were just asserting that they, quote, we can't draw a distinction between the fruits of mental and physical labor, unquote. Right? They just said, we can't distinguish between these types of labor. Well, in fact, it was very easy for legal scholars and lawyers to do just this. And Bentham pointed the way to distinguishing between two types of property rights, between IP rights in inventions and property rights in land. Now remember, Bentham said that property has nothing to do with securing the fruits of labor, right? It's about minimizing conflicts over existing resources and thereby providing security and safety. Now, given this new utilitarian standard for justifying the state's protection for property, people quickly realized that there's no conflicts over ideas. Right? One man's use of an idea does not prevent another man from using that same idea. An idea can be copied endlessly and used simultaneously without any conflicts between the users, and even more importantly, without any degradation in this idea, right? I hope this is true. I'm a teacher. I teach new ideas to my students all the time. I hope the idea doesn't degrade between me and when I teach it to the students. Now, in contrast to an idea about a new machine or some form of new technology, which can be copied and used endlessly, there are conflicts over the use of land and other tangible objects. In fact, with land, you can perceive this point. You don't need a theory to tell you this. As a judge observed in the early 20th century, quote, "Two men cannot plow the same furrow," end quote. In utilitarian-inspired economic terms, land is a scarce resource, but ideas are not. What this means is land and other tangible goods are naturally exclusive. Two people cannot use them at the same time, and they're exhaustible. They get used up. Ideas, however, can be copied without excluding any one person, and as they're copied, they are not diminished in any way by this copying. Now, this should not sound alien to you, right? What I just explained. Many people today exploit this fact by engaging in massive piracy of songs, books, and movies over the internet. And they rationalize it in exactly these terms. If you have young children, you've heard this. Or those of us who work in the universities, we hear this again and again and again. The refrain that we hear from college students today, right, is that illegally downloading a digital copy of a song is different from, say, taking a bicycle, right? Well, why? Well, they say, well, because when you take a bicycle, you deprive its owner from using it, right? But when I illegally downloaded my pirated copy of the latest song by Britney Spears, right, or some other artist, right, the Britney Spears or the person who even purchased that song legally, they're not prevented from listening to that song or using it for their enjoyment just because I have an illegal copy of it myself. As Rand explained so many times, philosophical ideas always filter down into the culture and are put into action by people who may have never heard of the name Bentham, studied the philosophy of utilitarianism, or even studied the economic concept of scarcity. And yet these are the very ideas that they're using when they rationalize their piracy of copyrighted works over the internet. Now, there's another reason why we care about Bentham, and not just because he's the source of the rationalization for young kids today in their violation of IP rights. It's because historically, the utilitarian claim that scarcity is the basis of property rights quickly became the principal argument against IP rights. As I said, it was adopted by many lawyers and politicians in the 19th century. Just one example was adopted by everyone in the populist movement that was led by President Andrew Jackson, and known at the time as Jacksonian Democrats. But today, the best-known advocates of this viewpoint are libertarians, right? Including many prominent ones, such as Friedrich von Hayek, who embrace the same argument. But it's also, you hear it advocated by scholars at the Cato Institute or at the Ludwig von Mises Institute, who vehemently, continually attack IP as a vicious, coercive, artificial monopoly. Now, the attack is always the same, and it always starts from the exact same first premises first laid out by Bentham. They argue that property rights are a legal solution to the problem of scarcity of existing resources. And thus, property rights are created by the state to resolve conflicts over these scarce resources. And why do we like to resolve these conflicts? Well, because therefore we provide security to the owners of these resources who can thereby internalize the costs and benefits and the use of these resources, maximizing the efficient use, leading to a market. Now, since the starting premises here are always first, scarcity, and second, conflict resolution, the logical conclusion of this is inescapable, and that is that IP rights are unjustified because they represent merely artificial scarcity created only by law, right? Ideas can be freely transferred. Books, music, computer programs can be freely copied, but for the legal prohibition that prevents you from doing it, not the fact of scarcity. In other words, IP rights are solely the result of a monopoly grant, they argue, from the state. Now, this artificial scarcity in IP rights they maintain violates the very rights to liberty and property that are based in the fact of scarcity in physical resources. Now, let's concretize this point. Imagine a patent on a computer program, right? In fact, there's lots of patents on computer programs. Microsoft owns hundreds of patents on the various codes and methods that underlie Microsoft Word, for instance, in addition to having copyright protection in the code as well. So it has overlapping IP protection. Now, on the basis of these patent and copyrights, Microsoft can control what I do when I buy this program from Best Buy, right? And we all know these prohibitions. Microsoft, for instance, prohibits me from copying it, a straightforward one. I can't make a copy of it. But it does other things too. It says I can't, for instance, put the program on more than one computer. And it also prohibits me from using it for commercial purposes, right? Microsoft is able to exploit its patents and copyrights to engage in what economists call price discrimination. It charges different prices to different segments of the market. It charges more money to commercial users than people like me, personal users of its product. But the idea and the technology of Microsoft Word is not scarce, right? Only the actual software on my computer is scarce. Thus, libertarians argue, I should rightly be able to claim from the government a legal property right in my physically scarce good, right? The actual software, which is a type of personal property on my computer. Thus, for instance, if Dr. Brooke wants to use my computer and I'm using it, I can say no to him because I have been given a legal property right as the basis to resolve this conflict over who can use my computer at the same time. The computer is just like land in that respect. And thus, this property right stops conflict. But according to libertarians, Microsoft claims a property right in the technology itself only because the government has granted it a monopoly that creates artificial scarcity, its patents and copyrights. And they claim this artificial scarcity is invalid and unjust because it interferes with my use of my own personal property. Right? My own personal copy of the program on my computer. They say Microsoft is dictating to me my right to use my property, my computer and the program that I've purchased. Why? Because they have a patent or copyright. Now this example about the patented software reveals, I think, the fundamental error in the utilitarian-based scarcity critique of IP rights. Right? The question to ask is, if the purpose of property rights is to prevent conflict over economically valuable goods, like a computer program like Microsoft Word, where did these economically valuable goods come from? Where did all of those boxes of Microsoft Word on the shelves in Best Buy stores come from? Now, libertarians don't answer this question, right? They just assume these are pre-existing scarce physical resources over which there might be conflicts or not. But as Rand recognized, this is the question to ask. In fact, she had another great line. Check your premises, right? Always go down to the root fundamental premise, the source of the ultimate conclusion that one is making. And the question to ask that she asked herself is, what is the source of the values that make a human life possible? As I noted earlier, right, computer programs, life-saving drugs, and machines are not just lying in the forest waiting for us to pick them up and use them like the berries that are there for a rabbit. They have to be created and conceived of by the people who create them. In fact, there cannot be a free market in which there are economically valuable goods, let alone there can't even be a science of economics which explains price theory, without men first conceiving of and then producing the values necessary for their survival. For instance, there's no conflicts over a fallow, unpossessed, and unused piece of land. There may be conflicts over who uses and benefits from a farm or a skyscraper or a factory that is created and then built on that same piece of land, after those values are conceived and created. Even better, there were no conflicts over the oil that was just 100 feet below the ground in 18th century Pennsylvania. Zero conflicts. No one was fighting over that oil. It was just waiting there. In fact, it used to seep up to the ground, and the American Indians used to soak it up and sometimes use it on their canoes and things of that sort. But there were no, people weren't fighting wars over it or battling each other. Well, why not? Because it wasn't a value. Why wasn't it a value? It wasn't a value until the invention of oil lamps and the combustion engine in the 19th century, in which we needed to use oil to run those types of devices. Following those inventions and many others like plastic, asphalt, and today, Blu-ray discs, there may now be conflicts over that oil. And there is now a market for whoever discovers it, draws it from the ground, and processes it into gasoline and the other petroleum products that are sold and used today. The potential for conflict, right? Or even more fundamentally, because that's the wrong perspective, the potential for profit, right? Because the idea here isn't destruction. It is, what is it necessary to live? The potential for profit presupposes the identification and creation of values in the first place. And it is only after the creation of those values, whether it's oil or real estate, that they can then be sold in an economically advanced division of labor society. So the point is that Bentham and his modern followers, and here it's the libertarians and economists who attack IP rights as invalid monopolies, they're using this economic concept of scarcity to deny the meaning and source of all property rights, value. More specifically, they're ignoring the fact that values must first be produced, and that this is fundamentally a moral activity, not an economic activity. One individual on an island needs to know how to use his mind in order to produce the goods necessary for living. That is not an economic activity at that point. You don't have economic activity until you have production and trade and what we have in society today. And why does that individual need to know that production is a moral activity? Because he's a rational animal for whom his mind is his basic tool of survival, which is the ultimate source of the values and those, which is the ultimate source of his values. And those things that he has then first conceptually identified and then physically produced in order to survive and flourish. Without the valuing rational mind that creates new things in the world, there would be no human life, and thus no property, and thus no organized free society, and thus no free market to replace all those conflicts over goods about which the libertarians and economists are so concerned today. But you know, the libertarians' argument against IP is doubly perverse because it's presented in the name of a so-called defense of property rights, right? So it's not only wrong in substance, it spreads further confusion and misunderstandings about the true source and nature of property. In their attacks on IP, libertarians deny the very foundation of all property rights, the rational mind that conceives of the values necessary for life and then engages in the actions necessary to produce those values as guided by the rational mind. Instead, the libertarians end up embracing the same anti-mind collectivist premises that drive leftists to condemn all property rights, whether in land or in inventions. Now, as an aside, some of you might be wondering about this. There are attempts by some utilitarians to defend IP rights on the basis of their collectivist standard of the greatest good for the greatest number, right? And some of you might be aware of this, right? Some utilitarians recognize that more inventions, more books, more trade secrets means more goods for everyone, right? And they recognize this. We want more inventions. We want more products and more computer programs. And thus, they argue that the government incentivizes these new creations by offering monopolies to their creators, right? So they dangle the carrot of the monopoly as the incentive to the inventor to come up with the invention. We promise you a monopoly if you come up with a new product, right? And then they say, well, we justify this monopoly, they call it a monopoly, because the short-term social cost of these monopolies is outweighed by the overall long-term benefit to society by this new creation that has been created. And it's important to recognize that even some non-utilitarians bought into this argument for IP. You might be surprised to learn that Thomas Jefferson, the author of the Declaration of Independence, argued in 1813 in a letter to an inventor that patents were, quote, embarrassing monopolies, end quote, whose sole justification, if any, was that they increased, quote, social utility, end quote. And this letter has proven very influential. It's been cited at least 2 or 3 times by the modern US Supreme Court in its patent cases. But these arguments are doomed to failure when they're pitted against the exact same collectivist appeals to the public health, the public good, social welfare, and the public interest that are always used to trump property rights, right? Under this moral standard, for example, courts and congressmen are asked to weigh, on the one hand, a pharmaceutical company's profits in the some type of patented medical technology, such as an AIDS treatment or perhaps a test for a cancer-causing gene, versus, on the other hand, the public health demands of the overwhelming number of needy people throughout the US and the world who may not be able to afford the price that the pharmaceutical company charges for the use of its patented technology. Right? The results of such balancing tests in court cases and in legislative debates have been entirely predictable. Right? The owner of the patent, the owner of the property right in the new drug or medical technology, who's standing up and saying, this is my property, which I can selfishly use for my profit and the decisions that I want to use for my own life, loses against the moral claim of the people who are most in need. Now, if there's anyone here who works in the biotech or the pharmaceutical industries, you'll know that this is not just a mere prediction. Just this past March, in New York, a federal district court ruled that all gene patents are invalid on the basis of a lawsuit brought by poor and needy women who could not afford the price charged for a test for the gene that causes breast cancer. So this is not just mere prediction. This is actually playing out in reality. Moreover, for any of you who know the history of this country, you'll have a strong sense of deja vu in what I just said. Because patent owners are starting to lose today just as landowners lost on the exact same terms 100 years ago. Right? 100 years ago, when courts explicitly weighed their private selfish interests in the use of their land against the public interest demands for zoning and other types of regulations of that land. In fact, my colleagues who are economists that I work with, you don't even have to go back 100 years. My colleagues that I work with today are all scratching their head about what happened, what has happened over the past 2 years. Didn't we win this battle in the 1980s? We're proving that all of the socialist programs of the 60s and 70s were an economic disaster. Why all of a sudden are we returning back to the exact same programs that are a disaster? And they're scratching their heads. And the answer is because the fundamental moral premise of this collectivist ideal of the needs of the many was never challenged. And thus, in a crisis, people return back to their first principles, their first premises. They return back to the standard as the way to judge how they're going to act. And that's exactly what we saw happen in the past 2 years. Now, Rand's justification for IP avoids all of these problems because she provides the first objective moral argument for all property rights. Right? She recognized that property rights are not based upon bald assertions about labor, on economic scarcity, nor are they based upon conflict resolution. In essence, value creation is the source of property rights. And this is the significance of Rand's concept of property. She properly grounds the moral justification for property in the values that man must produce in order to live. And this productive work, the skills, the inventions, and the myriad other objects that sustain human life create values, and it is these values that comprise property. And it is the right to property that secures the freedom in society that is necessary for each man to practice this virtue of productivity, creating the values necessary for him to live and flourish. Rand thus defines the right to property as, quote, the right to gain, to use, and dispose of material values, end quote. And the ultimate intellectual source of these material values is the reason why patents and other IP rights are an exemplar of this definition. In sum, technological inventions are the values that the rational man first conceives and then produces in order to live and flourish. For those of you who've read Atlas Shrugged, as you know, whose theme is the role of man's mind in his life, you should note that it was not mere poetic license, that Rand singled out patents as the property for nationalization in the infamous Directive 10-289. As I observed earlier, the Industrial Revolution provided the evidence necessary to confirm Rand's all-important discovery that, quote, man's mind is the root of all the goods produced and of all the wealth that has ever existed on earth, end quote. And Rand's incredible induction from the Industrial Revolution that man's mind is his basic tool of survival is further supported by the fact that the Industrial Revolution went hand in hand with the legal revolution in securing to inventors and innovators their IP rights. So in conclusion, Rand writes that, quote, what the patent and copyright laws acknowledge is the paramount role of mental effort in the production of material values. And although she states this point in the context of patents and copyrights, it's important to recognize that this principle applies to all property, whether in land, personal goods, oil, water, or inventions. Since man's mind is his basic means of survival, it is man's conceptual knowledge and skills that are the source for creating all material values. And for this reason, all property is fundamentally intellectual property. Now, this point cannot be understood unless the path is cleared by the long-standing confusion concerning what is value, production, and scarcity, as well as confusion concerning the source and meaning of values in human life. And so the justification for property rights requires working logically from your first starting premise, the concept of value. Then next, to the recognition of that man's mind is his basic means of survival, which then leads you to the recognition in ethical theory that productivity, the creation of these values, is a virtue, which then leads you in your political theory to the application of these ideas to man's life and society, that his rights to life, liberty, and property should be secured to him under the law. Now, once you do this, you can then fully understand that it is neither Locke's appeals to labor nor Bentham's appeals to scarcity that serve as the source of property, either in land or in inventions. Rather, it's the rational mind that identifies the values that must be created, conceives of the skills necessary to create those values, and then acts to produce them in the world. Now, in The Fountainhead, Ayn Rand has her hero, Howard Roark, explain, quote, "We inherit the products of the thought of other men. We inherit the wheel. We make a cart. The cart becomes an automobile. The automobile becomes an airplane. But all through the process, what we receive from others is only the end product of their thinking," end quote. To fully grasp this point and to see the full justification for property rights, it is necessary to recognize that property is rooted in the values that individuals must first conceive in their rational minds and then act to produce in the world. And it is only from this fundamental philosophical perspective that you can see that all property, carts, cars, airplanes, farms, computers, and all other values invented by the human mind are fundamentally intellectual property. IP rights exemplify this point in its purest form, because these property rights, in fact, directly secure the values created by man's mind. So, thank you. So I'm happy to take any questions you might have in IP, or if you have any general questions, Dr. Brooke is up here. Yes?
We've got a mic there. If you don't mind going to the mic, we would appreciate it. Thank you.
I teach a course at the Henry George School on progress and poverty, and in my introduction I use the example of the engineer at Texas Instrument who invented the integrated circuit, which revolutionized technology. He patented that idea and put it in the public domain. And we're all a lot better off that he did that. He could have kept on and charged huge royalties, and it would have slowed down the whole process. So there's a problem. I mean, I think some of these people that are trying to extend patents and stuff way farther than they were before, that's ridiculous. I mean, maybe there's some need for protection.
Actually, your understanding of the history is slightly incorrect.
Yeah.
Jack Kilby invented the integrated circuit, but so did Robert Noyce, who was at who was at Fairchild Semiconductor in California. Jack Kilby was in Texas, and they both sought a patent on their inventions because they were independent inventors. And they ended up in what's known in patent law as an interference action, where they were in litigation with each other as to who was the rightful creator of the patent. Jack Kilby, as an historical matter, beat Robert Noyce by about 2 months. So which just happens in patent law sometimes. Well, after spending some time, a couple of years in this litigation, they decided to simply resolve the litigation by not claiming patent rights in either of it, just to end the litigation. But so he didn't out of like, oh, I'm just going to just put this in the public domain. He did it because he realized that that the type of products that they wanted to then create on top of this, they were kind of chomping at the bit to get going with the digital revolution, and they knew that it was being held up a bit by this litigation, which was at that point leaving in a state of uncertainty about who actually had the property right. If you didn't have the independent invention, Jack Kilby would have gotten the patent, he would have licensed it, and it would have been fine. And he would have licensed it. He would, I mean, or Texas Instruments would have used it, and then they may have licensed it or may not have, right? But the point to recognize is that since it was their property rights, they could make that decision. They had the right to make that decision. As Ayn Rand said, the right to property is the right to acquire, use, and to dispose. And you have the right to dispose of your property if you want to, in whatever way you want. Sell it in the marketplace or give it away at times, but that was their right because the law recognized that they had a property right. Jack Kilby would have eventually won the litigation. He just decided they didn't want to deal with it anymore and that they would just resolve it between the two of them. And it's improper to actually say, well, you know, everything would have been held up for so long. That's actually incorrect from a couple different perspectives. One perspective is that it's incorrect because people would have licensed the technology or used it. But more importantly, very oftentimes when someone gets a patent on something, it has to be published. So the invention is known, and then people, what we call in patent law, design around, right? They create alternatives to compete in the marketplace with this product. And this is very common, and it happens. And the only way that you can have the competition in the marketplace, though, the only way that you can have, very importantly, venture capitalists, right, who are there ready to pour billions of dollars into a company, is you first have to have property rights. But many people don't recognize that contract rights presuppose property rights. Property rights are the subject matter of contracts. And so you can't just say, well, people will invent and then they'll go out and contract in the world. No one's going to enter into an exclusive contract with you if you don't have the exclusive property right to it to say, I'm going to give you this product that no one else will or can have access to in a certain way. And so it's the existence of the patent system that made possible for them to do what they did, and for people then to license and build off of their invention in the way that they did. In fact, the Congress, there was as another example of this, Congress recognized in the early 1980s that there were lots of inventions that were not being exploited in the marketplace because these were inventions that were created through public funding, through NIH and other sources of the government, public funding of these inventions. And the inventors, since they got public funding, didn't know if they could apply for patents, so they weren't applying for patents. And they recognized that lots of inventions were languishing because people were unclear about what was the property right status to this, and they didn't want to invest the millions of dollars necessary to ramp up your production facilities if at the end of the day, someone might swoop in to say, you can't do this, or more importantly, someone else might kind of just say, oh, I'm going to free ride off of your efforts and take your market share from you. And so Congress passed a law that said, it doesn't matter if you get funding or not, if you're a university researcher, you can apply for a patent. And this immediately brought a boatload more inventions and technology to the market as a result of this. And just one final example of the efficacy and the importance of property rights in the patent system, the reason why the biotech revolution happened, and more importantly it happened in the United States, was because of a single US Supreme Court decision in 1980, Diamond v. Chakrabarty, where the US Supreme Court said you can patent genetically engineered organisms. It was a genetically modified bacteria. And there were all the arguments at the time that said you can't do this. In fact, the Patent and Trademark Office had originally said you can't do this. This is life. You can't patent this. And it goes all the way up to the US Supreme Court, and the US Supreme Court says, this is a discovery, this is an invention, this is a new value created by man, and it should be propertized. And as the result of that decision, billions of dollars flowed into what became the biotech industry in the United States, and it's why the United States was the leading source of the biotech revolution, because Europe and other advanced countries disagreed with the US Supreme Court's decision, and they actually argued you can't. And they didn't get into the game until much later, until the 1990s, when they realized, oh my gosh, this is actually a great thing, not a horrible thing. And then they permitted people to do this. So repeatedly, recognizing property rights in inventions and discoveries is the source of value creation, is the source of wealth, it's the source of economic activity and progress, not the other results.
Hi, I'm mostly, on track with everything you said and what Ayn Rand said, with the exception of land. Land is, a special thing. It's one of the factors of production, and it preceded man. Man did not create land, and you can't really, you can deplete things from land, but the location itself is still there. And I'm also a Georgist, like my colleague up here that asked the earlier question. So what gives land value is the community. I mean, essentially, somebody buys you can go to Chicago and buy an empty lot, go to sleep for 30 years, and then wake up, and because of all the schools and shopping and highways and the infrastructure and public transit, that makes that land valuable, and then you can cash out for 20, 30 million and go on your way, and you have exerted no labor whatsoever, to earn that value. So I just have kind of a fundamental problem with that. I wonder if you'd maybe kind of address that somewhat. Now there's a difference between land and improvements. Now putting a building on land, skyscraper, that's fine. That's property, something that you create. When you exert labor on land, you create something either with your mind or whatever, that's your property, and you have a right to sell, trade, and all that. But shouldn't land belong to everybody because you are excluding other people from its use when you're using it? And shouldn't you pay the community a rent for the use of that, your exclusive use of that land?
Okay, so everyone heard the question, what about land? Well, it's very important to recognize that land is not property, right? The value in land is not from the land itself. It's from human action and the purposes which people use the land. So there's a tendency to think like, oh, land is intrinsically valuable. Land brings value there's value in land before humans do anything to it. And this is one of the mistakes that Locke actually made. Locke actually said that there is some value in the land before you start laboring on it. That is a mistake. There is no value in land until someone identifies a purpose which to use that land. For instance, a parcel of sandy land, right, in the desert, is of no value if your purpose is farming, right? But if your purpose is manufacturing silicon for computer chips, that sandy parcel becomes extremely valuable. It all depends upon what your use of it will be, because it's the use that converts it into a value, right? Now, as you get into advanced, complex technological societies with division of labor, right, you get network, what we call them in the law sometimes, network benefits, where one person's use of their land has spillover benefits for your land, et cetera, but you have to get to the Rand's justification for property was you have to get to the root source of what is the ultimate beginning point for land. So the person on the desert island, what is the value in that land? None until he starts to do something with it, until he builds a hut on it, or until he starts farming on it, or until he starts cutting down. You could say the same things about trees. You can say, by the way, the same thing about trees and all the other things, the so-called natural resources, right? The gold and all that sort. All that stuff has been, your argument has been applied to everything.
Everything is land, all material.
Right, but land isn't anything. It's just a descriptive fact of the world. What you're talking about is real estate. And real estate is a value only insofar as people have then taken actions to do things with it. Now, it's very important here because I think the source of your problem is that you are conflating value with economic value, right? You said, oh, this parcel becomes valuable. Well, what do you mean? You mean economically valuable. Okay, now you're presupposing a complex society with division of labor and trade, and people can make long-term forecasts about investments. All right, I'm going to buy a piece of parcel of land because I see a city is growing, and I'm going to make a long-term forecast about where the value of this, economic value of this land. But it's important to recognize value is not economic value. Economic value is a derivative sense of it. Value is a moral concept, not an economic concept. Value is that which people act to gain and or keep to maintain their lives. And you have to go to that foundation. And this was one of her radical insights, because this is how she solved the whole philosophical is-ought problem, is her discovery of the concept of value and how it applies for living beings. And so you have to recognize that all the things you're talking about follow from the creation of those things by people. Now, is it true that there are some people who inherit wealth and things of that sort? Or is it true that some people luck into wealth? Yes, right? You might be born into a wealthy family, you may not be. But those are accidents. And you don't define moral concepts by accidents. You define moral concepts about what is at core related to the essential nature of man, and then you work from there. And sometimes people accidentally get wealthy. Sometimes people end up accidentally poor. that can't be what we're concerned about in morality. In morality, we have to be concerned about what people justly deserve and don't deserve at root. And if you bring into moral evaluation things that are from outside people's control, then you end up undermining the very function of morality.
Yeah, let me just, as an economist, let me just address the actual example that you give, because I think it's false. I know lots of people who bought parcels of land, let's say in the outskirts of Phoenix or Las Vegas, and have lost a fortune, because they didn't predict the real estate crisis that's happening right now and didn't see that. So the choice of picking where you're going to buy the land requires effort, requires real, real intellectual work, conceptual skills, economic skills, predictive skills, and people lose money all the time on land. Now, if it was so easy to create wealth, then wouldn't we all just buy plots of land somewhere in Chicago and sit on them for 30 years and we become wealthy? But of course, the fallacy here is twofold. One, it's not that easy to predict exactly where the good parcels of real estate are versus the bad parcels of real estate. But it's going to depend on other people creating value. As you said, it's a community thing, right? Other people can't just sit around on their land. So you're still dependent on somebody using his mind to create real value, to build stuff with that land. So even though your land is fallow, you haven't done anything with it, somebody else must have done something with it, with their parcel next door, and you're the luck does happen, the lucky beneficiary or the thoughtful beneficiary, because you planned it, of somebody else's benefit. So you've got a positive externality. But so what? I mean, that doesn't change the fact that the value of the land is only a result of the fact that somebody is doing something with that land or plans to do something with that land.
CTA builds a new L stop across the street from somebody's apartment building. The rent is all going to go up in that apartment building.
Yeah.
And again,
Yeah, you got lucky. You got lucky because somebody applied their mind to create something. I mean, CTA is a little pushing it, but you know.
Adam Smith says in the conclusion of chapter book 1, he says that all benefits of a society accrue to the landowners.
But that's simply not true. Adam Smith is wrong about a lot of things. He's a genius, but he's wrong about a lot of things, and that's simply not true. I mean, for example, Mark Zuckerberg from Facebook owns no land, and yet is several times over a billion. And I know people who own quite a bit of land in outskirts of Phoenix, and have nothing.
Are negative billionaires.
So it's absolutely not true. And the problem with Adam Smith, as with Locke ultimately, is that they have a certain materialistic view of value creation. It's exactly what Adam was talking about. They don't see the role of the human mind in creating values. And as a consequence, both of them adhere to the labor theory of value. That is, they both believe that value, economic value, put aside the moral value, economic value is created through physical muscle. And in that sense, they're no different than Marx. And this is why Marx seems reasonable when he comes around, because he's just building on a foundation established by Locke and Adam Smith, the founder of capitalism. Because Adam Smith implicitly accepts a labor theory of value, which Marx then, takes to its full conclusion. Ayn Rand rejects the labor theory of value. The whole idea is that economic value and moral values are not created fundamentally through physical labor. They're created through mental effort. They're created through the use of reason, the use of the rational mind. And she rejects that whole tradition, going back to Adam Smith and to Locke, and that's true. If you're a materialist, if you believe that all value is created through physical, I mean, you've got a lot of explaining to do, but beyond that, yeah, then it's true. All value ultimately goes to the landowner or to the owner of the physical assets. But it's not true. That assumption is simply wrong.
There's a microphone, by the way.
Yeah, there's
with a line of people, so if you're interested.
It's not that long. Yeah, a few comments to make. The first comment has to do with Facebook and the idea that if Mark Zuckerberg would have listened to that cease and desist order, we very well may not have had Facebook. And of course, the cease and desist order is a product of what happens when the government enforces intellectual property rights. The second is a question. in terms of do we own the rights to our own ideas that result in productive value, in the same sense that you could say that we own the rights to our own reputation, which is nothing more than a collection of other people's subjective attitudes about us. Another question is the inventor of a chair, the original chair.
Actually, you're monopolizing the question period by asking a series of questions. Can you just ask one question that I can answer?
I'll just say, if you look at the invention of a chair, would somebody who improves upon the chair and takes that idea and
well, you've already asked two questions. Don't ask a third question.
Okay, that was the one I'd rather focus on. The invention of a chair, if somebody makes a better invention and enhances its value, would that person then owe royalties to the original inventor of the chair? And at what point do you stop and say, well, these are separate inventions? How is that consistent with being someone who believes in the man's mind and that creates all value?
All right, well, that's a great question, but realize your question is not specific to chairs or IP. That's a question that raises in all property contexts. In law, it's called the accession doctrine, which applies to land and personal goods. This is a question that courts have wrestled with for hundreds and hundreds of years. You know, what happens if a man goes onto another man's farm and plants a tree? Who gets the tree? Right? Because there was value created by the man who labored in the other man's tree, and of course, and then the man would sue, saying, "Oh, I get the tree," and the farmer would say, "What are you talking about? It's my land," and they would go to court. So this isn't a special problem that only deals with. I assume you're talking about patents in terms of patenting the chair and whatnot. The issue of multiple contributions to a piece of property, whatever that property is, occurs in land. It occurs with personal goods. It occurs oil and gas and all air. It occurs in all sorts of types of property. And the law has lots of doctrines to address it. It's a very difficult issue to contextually identify, and lots of issues come into play, like the importance of certainty, for instance, right? Or, so for instance, with respect to land, right? The courts ultimately settled on the rule that the owner of the land gets whatever property that's put upon it. Just because one, people should know if they're going on other people's land, right? You know, if you see a nice cultivated field and you plant a tree there, you're kind of on notice that it's someone's land, right? And then you might lose your tree. But second, like the value of certainty in knowing that this is someone's property and that the courts are not going to be making these fine-grained, you know, regulatory type distinctions between, well, this person gets 0.000002% of the value of your farm and the farmer now gets only They didn't want to get into this type of active regulation of people's economic affairs, and they said, so we're just going to draw a bright line. And yes, it might be unjust in some contexts, but with respect to the equal protection of everyone's rights, this is the rule that makes most sense. Now, in the context of patent law, you will often get what are called improvement patents, which are patents that follow upon an earlier patent. And the point is that they have to license with each other. And that licensing occurs all the time. Millions of dollars change hands every day between patent owners. And in fact, I don't know if you know this, but the Droid and the Apple iPhone, these have like each of these phones has several thousand different patents that apply to them. And that the licenses were purchased with a couple clicks of a mouse and some quick negotiations. In fact, there's now some growing patent lawsuits over some of these patents, but just a few of them. All the other ones have been licensed and easily licensed because there's profit at stake, right? There's people's lives at stake. People don't want to get dragged down into litigation. Litigation's costly. It's the point that I talked about earlier about Kilby and Noyce, right? They wanted to get down to the business of producing value and becoming rich and bringing new things to the world. And that's what people do. That's why people expend the cost to get patents, and it's why they use patents in the marketplace. Now, the exact rules, there are particular legal doctrines that address, like, at what point is an alteration to an existing invention inventive enough to count for a new patent and whatnot. But that really gets down to the nitty-gritty details of the patent system that I see there's a long line of questions, so I don't want to get into that. But take a patent law class. I mean, you'll be surprised to find out these issues have been around for hundreds and hundreds of years, and the courts have addressed them. And I think they've addressed them basically well. The rules are fairly good. They recognize sometimes that this is a complex issue and that they have to get at exactly how best to resolve it. But they do resolve it because they also recognize that People are waiting to benefit and live and profit from these property rights, and that's what people ultimately want to get down to the business of doing.
Well, let's do these three and then we're done.
I'm one of those skeptical.
Short questions,
Yeah.
though.
I'm a
Short
skeptical
answer.
libertarian who's actually in the process of patenting an invention right now. So I'm, I'm interested in this idea and these ideas very much. My question is, from a practical standpoint, is the logical end of enforcing IP on something like music, which is, it can be transmitted now digitally through bits on the internet, is the logical end of that akin to censorship?
Well, no. I mean, this idea that IP, especially in the copyright context, represents censorship, right, is a move by collectivists to try to destroy IP. It started in the 60s with leftist legal academics arguing that, oh, words are speech and copyright controls words, therefore we can help get rid of this IP right by calling it censorship, knowing under the First Amendment that you can't have censorship by the government of speech. And what it's led to, unfortunately, because courts today don't understand property rights or rights generally, is these complex balancing tests. We have to balance the First Amendment against the copyright and patent clause and figure out these things, these difficult issues. And they recognize that the domain of property rights is distinct from the domain of free speech. That when you have a property right, for instance, your home, you can say whatever you want, including telling people who come into your home to spout off leftist doctrine, get off my property, right? They can't then say to you, oh, well, the government enforcing this property right in your home is censorship of my right to spout off leftist doctrines in your home. But if you realize that's the exact same thing that you just said about people having copyrights in music, preventing other people from copying that's the government censoring their ability to express their speech. It's the exact same idea. And if you recognize that property helps define the sphere of which you can speak, actually, then you can recognize that there isn't a conflict here.
Hi. I would say that it's very hard to tell a college student that they can't download something if they can go to the Chicago Public Library website and download every single best-selling book on the New York Times bestseller list for free. Why is it okay to do that with the library, but if they go to Pirate Bay, they're breaking the law? I would say that libertarians are not attacking intellectual property. What is being raised is the question of the business model. When I go to a used bookstore and I see hundreds of books, or I go on eBay and I see people selling books, what is the publisher getting from those resales? What does the author get from those resales? Obviously, the model is flawed. When it comes to downloading material, what we are doing now is spending tens of millions of dollars.
We're short on time, actually.
Okay. I believe that the business community needs to understand the technology and change their business model. Right. It is not an attack on intellectual property.
All right, actually it's wrong. I mean, if you go actually onto the web, you'll find books called Against Intellectual Property, written by libertarian economists. And if you go to Ludovic Mises' website, you will find lots of people, and if you go to Cato, you'll find lots of people that are saying IP is a coercive government monopoly that should be eradicated and eliminated. So you actually are wrong. They're not critiquing just the business model. They are attacking the concept of IP rights. And there's lots of people who are publishing works on this. Tom Palmer and Stephen Kinsella, and I could ladder off names after names after names of libertarians who are on the position that intellectual property is an invalid, unjust concept. Now, you have to separate IP from the business model, but you have to realize that if a business is acting irrationally, the solution to that is not to destroy the property rights that they have. Right? The business has the right to act irrationally, just like you have the right to act irrationally with your property in your home. Someone may disagree with you about what you want to do with your house, or even be irrational about it. That doesn't give the right of someone else to come in and say, all right, we're wiping out your property rights in your home because you're not using it properly, right? According to how we think how it should be done. You know, the market, if business models are ineffective, the market will respond to that. And old business models that are no longer responsive to new technology will be replaced by new ones. This is the story of the history of this country. Railroads were replaced by automobiles. Automobiles for long distance travel were replaced by planes. And until the TSA reversed this course, this progress would have continued into space, right? Old business models are constantly replaced by new business models based upon new technology. And the point is to let that happen. Don't get the government involved in terms of destroying the very foundation of what makes those business models possible in the first place, which is the property rights.
One of the things I think people have been kind of touching on is releasing something into public domain, a copyright, say. That, you know, there is no question that if you hold a copyright on something, people are paying royalties for you, it's going to slow down getting your invention out into the public and their use. So I guess my question is, in that case, is it more useful to the public to actually be waiting that time? Because if you have to have the product wait to be released, it's making a more stable system. Yeah. Take, for example, like Chinese factories where,
okay, I understand the question. Okay. Your standard is incorrect. Our correct question to ask when we're talking about property rights is not what is more useful to the public, right? Because, for instance, it's more useful for the public that there not be slowed down to trespass over your land in order to get more quickly to the CTA subway stop, right? If you own a parcel of land that they have to walk around to get to, that's extra time, energy that they have to spend. You slow them down. Yet, the question then to ask is not, oh, okay, they're being slowed down, so we should eliminate your property right in your land. The same issue with respect to copyright. The standard is not, is the stuff being slowed down by the protection of these rights? The question to ask is, are the rights being effectively protected? Is the value being secured to the creator in the proper way? Because all property rights are defined by other people's property rights as well. It occurs in land. You can't use your land to the point that you damage other people's land. In the law, we call that nuisance doctrine. There's also other limits on land. People tend to think of land as this unlimited property right. It's not. Property rights are contextual in all contexts. So there's adverse possession doctrine, which will actually result in your land being transferred to someone else's land under certain conditions against your will. There's special limited types of property rights in land, like easements, which just give you a right to travel over a piece of land, not possess it. If you live in an apartment, you actually have a property right that's very limited. It's called a leasehold. I don't know if you realize this, but that's actually a property right. I teach that in my property class. And that's a limited slice of a property right that a property owner has granted to you, which prevents you from doing other things to other people who own their leaseholds, like play your music really loud at 3 a.m., right? And these are all defined appropriately given the context of the nature of the value that you have as a property right, and in the context of the equal protection of that value vis-a-vis other people's property rights. And that's always the focus to have. That's the standard is, are the values being secured to their creators? Not, what does the public need? If you start with the public need, you will result in everything that we have today. Obamacare, the Frank Dodd financial regulation, zoning, all the alphabet soup listing of agencies, the FTC, the FCC, the EPA, the FDA, the entire statist regulatory apparatus that we have today is predicated explicitly upon the concept of the public interest or the public need.
I'll just add one thing to that. This is one of the fundamental differences between libertarians and objectivists. We reject utilitarianism, and you have to say it maybe 75 times in a lecture. The standard is never where will the outcome for the most people be the best. The greatest happiness for the greatest number is not the standard. That is not the standard of objectivism. The standard of objectivism is what is right for the individual, what is moral, what is just for the individual, the unit that we deal with. And this is interesting, because libertarians claim to be individualists, but they're not philosophically. Philosophically, they're collectivists, in that they use utilitarianism as a standard. That is a collectivistic standard. We are true individualists. The standard is, does this person own this? If he owns it, let's say you just completed the greatest sculpture in the history of mankind, and you choose to destroy it, you would say, wait a minute, but people haven't enjoyed it yet. The greatest happiness, the greatest good, you have a duty to show it to the public and let them enjoy it. But it's not yours. It's the person who created it. They want to destroy it or just keep it in their house and only show it to their friends and never put it into the public, then it's their right. And if somebody, let's say somebody invents a motor a motor that can revolutionize all industry everywhere in the world. And he decides to take it to a valley and just use it with his friends. That's the whole point of Atlas Shrugged, is a rejection of that standard, a rejection of utilitarianism and altruism more broadly. John Galt has a right to do with a motor that he invented anything that he wants, destroy it, take it to the valley, or put it in a public domain if he thinks that's the right thing to do for some bizarre reason. It's his. He can do with it what he wants. Thank you all. Thank you, Adam. Thank you.